Legally Speaking, with me, Tarun Rangia. Today, we're going to speak on curative petitions entertained by the Supreme Court and the floodgates that will open if curative petitions are entertained in commercial cases, as has been done in the recent curative petition involving DMRC and DAMEPL, which is Delhi Metro Rail Corporation and Delhi Metro Airport Express Private Limited. What are the implications? I have an eminent guest today. He has served as the president of the Supreme Court Bar Association, not once but twice. He is also who has been at the forefront of taking up issues which are of concern to the bar and the bench, both with the bench when he was at the helm of the Supreme Court Bar Association, and also now he actively takes those up. He's also known to speak with a certain amount of clarity and frankness, and that is what is appreciated, that he puts his points across very, very succinctly. I want to welcome Senior Advocate Vikas Singh, one of the foremost and leading advocates and arguing counsels at the Supreme Court of India. Good to see you, sir.
Thank you, Tarun.
At the outset, I want you to give me a long answer explaining, first of all, the recent DMRC-Dampel curative which was allowed, and a large part of this, if you could share the implications of such a curative being entertained.
So, Tarun, to start with one small correction, I've been president thrice, not twice. And second caveat is that, to be honest, I don't know what facts of this case are. So I am really not commenting on the merits of what they have done. I'm more concerned with the manner in which it is done. Now, Tarun, if you will recall, in the Rupa Hurra judgment, there was a requirement of getting a certificate from a senior advocate for one to maintain a curative petition. Now, every now and then we get requests from people who want to file a curative petition and they want us to give a certificate. And we have been, very, very, reluctant in issuing certificates for the asking, even in cases where we have felt that there is miscarriage of justice, because we have understood the judgment to mean that it is only if you have not been heard, that is, if you were a party, necessary party to the proceeding, and you were not heard in the matter, or if you were, you have discovered later that the judge who decided your matter had a bias against you, and you have been able to prove that. In one case, I remember that there was a judge of this court had a bias. His sister's matter he had decided, and I gave a certificate in that matter. And unfortunately, that matter, and it was a very important matter as far as the jurisdiction of, public premises are concerned, vacating a public premise and all that. So that petition was not entertained. I don't know for what reason, but that, according to me, fell squarely within the parameters of a curative petition or curative jurisdiction. Now, when we look at the Indian judicial system, and I'm especially worried about the foreign investors, they want to have a certain amount of certainty in the rule of law. And why I say rule of law? Because ultimately there is a hierarchy of decision making. In this case, there is an arbitrator, there is a 34 petition, there is a 37 petition, and there is a Supreme Court judgment. Now, in a commercial matter, if a party gets a judgment in its favor from the Supreme Court, review petition also dismissed, to expect that his case will again be reopened is actually violative of the rule of law. There are so many cases where miscarriage of justice happens, and which really don't fall in the, the parameters of Rupa Hurra, and nothing can be done about them. And we see these cases a day in, day out, and we have to tell our client that ultimately you have to, reconcile yourself, because if we start advising all our clients that, even if you've lost out because you've got a good case, I can still try for a curative relief for you, I'm being dishonest in my profession, I feel. I'm duty bound to advise my client that, look here, now this is the end of the matter. I mean, it's a bad deal. judges were not with you, they didn't appreciate your point, that should be the end of it. And that is what is called the finality of decision making. So commercial matters, it becomes even more important, because in commercial matters, when a judgment comes, a lot of investments are dependent on that judgment. A lot of, bank loans are dependent on the judgment. A judgment can be even, given as a security, collateral, etc., where the amount is quantified. And all that is dependent, all that is, permissible in law to rely on a judgment. Now, if you can't do all that, and if you are, under the apprehension that in spite of a final judgment, the whole thing can be reopened and the finality can be set at naught, then really speaking, it strikes at the very concept of rule of law. And I feel that this will, so what will happen tomorrow? Every client who comes with a bad case, whom I feel has a bad case, I will perforce be forced to give him an opinion citing DMPL that, look here, DMPL, they've done it, they should do it in your case as well. So people like me who are not advising till now and telling people that you don't fit in the criteria of a curative petition in terms of Rupa Hurra, we will be forced to tell our client that there is a possibility, because now this Delhi Metro has opened this new avenue, and we'll have to sign these petitions. And if I don't sign this petition now, I will now be doing injustice to my client, especially when I feel that an injustice has been done to him, and which happens in many cases. Injustice does happen. But because of the finality, I remember one Supreme Court judge saying, in open court, that we are not right because we are Supreme Court. We are right because we are final. So that's the kind of, culture, a judicial culture that we have all grown up in, that once a Supreme Court decision comes, it is final, and everybody has to, it's the law of the land under 141, and it is to be followed by everybody. In fact, there have been many cases where I have felt that this judgment is wrong, but nevertheless, I've always said on many platforms, including TV channels, that so be it. I mean, that's the judgment, and that's the rule of law. It has to be followed. If we don't follow a judgment of the Supreme Court in this country, it will lead to anarchy. And we can't claim ourselves to be a sort of a developed democracy if we don't follow the judgments of the Supreme Court, or we don't follow the rule of law. So, according to me, this judgment is, in a way, opening up a new jurisdiction, a new jurisprudence of, unsettling what has been settled by, judicial pronouncements, and reopening the whole thing all over again. Because what they have really done, and that is only on the basis of what I have read in the newspapers, what they have really done is that they have really rendered a new award altogether, or rather they have rejected the claim of the claimant and, said that he is not entitled to anything. So this is again a prima facie view, because I have not read the facts of the case, but this is what the papers have reported. So really speaking, it's like they have behaved like the arbitrators themselves, rejecting a claim at the very threshold, as if they are the court of first instance, or judicial forum of the first instance, deciding the merits of the claim which the party had made before the arbitrator. So, really speaking, it's opening a new avenue of jurisprudence, which, according to me, is not something which should have been encouraged by the Supreme Court.
Would you say this because this article by an economist, Swaminathan Iyer, in the Times of India says that now there will be millions of commercial cases where the parties may feel that the Supreme Court has ruled against you, no problem, let's go for a curative. A. B, if you could explain that, will the judges in the Supreme Court also be wary that there is no sanctity of the judgment I author? I will retire, somebody else will file a curative, and if it is entertained, then my judgment will be set aside. Is this a fear, or is this overstating it?
So Tarun, so tomorrow, if once this members of this bench retire, and tomorrow another Chief Justice feels that this bench should not have reopened the curative in this manner, and review the curative, and say that this was not correct. Now, where are we leading to? And you are commenting on retired judges as if they have done some very great. I can understand, Tarun, in a case where after a review petition, you come to know of actual, there is a criminal case where money has exchanged hands and judges have taken money, and you come to know that later. Then to exercise curative jurisdiction probably may be justified, although really speaking, that also doesn't fall in the Urupa Hurra, principle, or the altar at which, or the pedestal at which the reopening of a curative matter has been held there. But probably it may be justified, because at least then it can be said to be that the judge had a bias against you, and that principle can be brought in by that method. But to cast aspersions on two very eminent retired judges that miscarriage of justice has been done, you are virtually saying that they have done something wrong for obvious reasons, and that is something which is again disturbing. Tomorrow, if you retire and your judgments also start getting reopened like this, and the comments are coming against you, what are we making of the judiciary? I've been president of the bar, and I've faced a lot of criticism. People have said a lot of things against the judiciary, but I have always felt that whatever issues are there in the institution, as president of the bar, I used to take it up in closed doors with the Chief Justice in his chamber, rather than going on a public platform or onto the press, etc. Because I feel that if the institution is not respected, then it is a great blow to democracy again. And if the institution is not respected, then what respect can we command in society? So we all gain our position in society by the respect of the institution. If there is no finality of what the institution does, then in some way or the other, the respect, or the I would say the aura of the institution is somewhere sort of fading, which will result in more damage to the institution than good to the institution.
One thing that came out of the article I was reading by Swaminathan Iyer in Times of India is that if it's a case involving fundamental rights or a terror case or cases like that, one can understand a curative being entertained. But commercial cases which are in thousands in a country, and as a country goes, say, to a much larger economy, there'll be many more cases, and Supreme Court judges will give judgment after judgment every single day. Will it also kind of make the judges of the Supreme Court themselves worried that whatever I am authoring, somebody will entertain a curative tomorrow and that can be set aside? So even the Supreme Court judges would now start to be, in a sense, feeling that what I am doing is not final. This can be, in a sense, even after viewing it will go to curative, it can be. So what is now going through the minds of businessmen, people working in the government on PPPs, etc., that India, nothing is final. Anything can happen anytime. And then what sort of a jurisdiction India becomes if these kind of things happen?
So, Tarun, so this is actually the first point that I made. This is actually a follow to the same. So if there is no certainty of what is going to happen after a final judgment of the Supreme Court, then obviously there is something wrong in our judicial system. And either we have appointed the wrong people who have, gone to the Supreme Court and delivered judgment which they should not have delivered, or there is something very seriously wrong with what they did in the manner in which they did. These are also casting aspersions in a very big way on the judges who dealt with the matter, or I would even say on the lawyers who dealt with the matter, because probably some of them may not have argued properly. And Tarun, I'll tell you, there are umpteen cases, and commercial especially, where I have felt that a particular point of view, if it had been argued properly, the judges may have taken a different view. But that is a call which you have to take at the time of making the argument. If you don't make that call, if you don't take that call, that's the end of the matter. Even in the review jurisdiction, people try to reopen the matter on merits. Now, review jurisdiction is also very restricted. It's an error apparent on the face of the record. So it's not an error which has to be corrected. It's an error apparent from the face of the record, meaning that it was before them, argued before them, and not noticed by them in the judgment, and it escaped their attention. So something as glaring as that. So review jurisdiction is narrower than a regular appeal, and curative is even further narrower than a review. And now in a curative to reopen the whole thing, in my view, definitely will unsettle the feeling amongst judges while deciding, especially commercial matters. And this will be more pronounced when they are handling matters against the government, because ultimately what has happened today is that in this matter, the public sector has ultimately been benefited at the cost of a private party in the form of the judgment which has been delivered by the Supreme Court. Because if the judgment had not come, they would have to shell out this money. So public sector can get away with whatever. They can not argue, not place their points properly, and still at some stage, because it is government revenue. So I have seen a lot of judges who have said that don't scare us by numbers. It may be a big number or a small number. We have to go by the law, by the letter of the law. And that's the oath that you take as a judge, that you have to go by the constitution and the laws. So if you are to go by the constitution and the laws, the amount involved in a commercial dispute has no meaning, absolutely. And just because the amount is large doesn't mean that you will use that.
I want to ask you, India is growing at a pace where infrastructure investment is happening in lakhs of crores. This will lead to disputes. Power sector is one of the sector where investment happens in the lakhs of crores. And a lot of time disputes happen and land up in the Supreme Court, which is a natural cause in any growing economy. Giving that in mind, do you think that we will need to take some decisions to instill confidence in the investor community that your money is safe? In case there is a dispute with the government, even then you will get your money. Don't be scared.
I don't think that this is something which the Supreme Court will have the right to do, or rather should do. For Supreme Court, as I told you, when the judges take oath, they have to decide as per the constitution and the laws. But definitely the government can think of enacting some law of giving finality to judgments and saying that the government itself will not file an appeal or not go in curative. And that will definitely instill, a confidence in people that government or public sector undertakings should not file a curative, and there should be some method of ensuring that this doesn't repeat. Because if it repeats, if it is something which is to be done frequently, then definitely investor community will feel threatened, especially the foreign investors who are coming in a market. A lot of people don't go to Dubai. Why? Because Dubai, they feel that it's a king's rule and king can do no wrong. And in many cases where the king himself is doing business, you can't even sue him. So India, fortunately, doesn't have that disadvantage, and anybody can be sued, and government has lost very, very big cases in the Supreme Court. And you will recall the Vodafone judgment, or in fact, many other judgments where, large amounts have been involved. And government has settled with that judgment. So in this matter, in this manner, in this particular case, why the government took it like this, and why did the judges also, take so much of interest in deciding this matter? This I really can't say because I have not seen the facts of this case. But whatever it be, in my view, this jurisdiction should be exercised very lightly and sparingly to instill confidence in the rule of law and in the finality of judgments of Supreme Court.
One final comment I want from you, that you highlighted this, that what would those judges be feeling or going through their mind that they authored a judgment which in curative, which was allowed, and effectively the judgment was set aside. Do you think that this also sent shivers down the spine of the judiciary, that these judges are in no position to talk of the case they decided on, given that the curative has been allowed. Many retired judges become arbitrators themselves. And when these kind of things happens, it, in a sense, in the judiciary itself, because you understand this from inside, I'm asking you, it causes certain fissures and fractures within the judiciary. That, if somebody retires and his cases are settled, it sends a message to people in the judiciary. I'm talking, this is amongst the judges. It has nothing to do with outsiders. If you could share that a bit as a last answer.
So, Tarun, we have known that there are camps within the judiciary. There have been books written on, judiciary, some judges aligning one way and the others aligning in a particular way. So definitely this kind of, talk will definitely start amongst the judges themselves. And they will all want to be on the right side of the Chief Justice, that they don't, at least in their tenure, don't end up. Of course, here in this case, the Chief Justice has changed, and invariably in a curative jurisdiction, the Chief Justice will change when somebody writes a judgment. But you never know. I don't know whether it was personal between the judges or it was a institutional issue which they thought they should have taken up in the curative jurisdiction. This only posterity will tell. We can't second guess what went through the mind of the judges. But yes, definitely, some judges will feel insecure in deciding matters of where there are stakes are high, and fearing that whatever they do may ultimately land up for another round of litigation. And that may have some good in it, may have some bad also, because they will also be a little circumspect in deciding matters and trying to see that they don't leave any loophole in the judgment, which will be good. But it will be more bad, because if they feel that their judgment is not final, it will be instilling a sense of insecurity in what they do, which is not good for the institution. Thank you, Tarun. I can't hear you now. Just your voice is gone.
It is a pleasure to talk to you because of two aspects: that you speak with great amount of clarity. You don't even mince words when you speak. I always get a feeling when I speak to you that, you don't go round and round like noodles and confused. Sometimes you get that feeling when you speak to a lot of people. They're saying what they want to say, but they're not saying it clearly. At least with you, it's straight what you speak, what you mean. It's a pleasure talking to you. Time and again, many times the Supreme Court has shown that when there is PPP with government parties, they will stand by what is right. And I think that is what should happen if India has to become a $5 trillion economy, because in the end, when you have business, you have disputes, and everybody looks forward to the courts. In this case, it took 11 years, and the curative has been admitted. So it's the whole 11 years have passed away. It's like more than a decade. That's a lot of time. But that is for another show to discuss another topic. Appreciate you joining us. Thank you so very much.
Thank you. Thank you, sir.
For more such videos, subscribe to the NewsX YouTube channel, hit the bell icon.